Your Honor, I appear today not merely as a petitioner, but a son of justice rooted in the ancient covenant of truth. I speak not just for myself, but every voice silenced by power and every light refused its place. I don't come in anger. I come in authority. May it please the court. My name is Reverend Lucius Conway. This matter is before the court on an emergency application for injunctive relief to prevent ongoing and imminent harm to the integrity of Detroit's August 2025 primary election scheduled for Tuesday. Harm that has now been definitively substantiated by the state's own election regulator. And for the record, Your Honor, the Michigan Department of State has conducted an independent investigation in direct response to the plaintiff's campaign finance complaint. Their written findings now before this court expressly confirmed that Councilmember Whitfield Calloway's official Detroit City Council newsletter was distributed using the city's GovDelivery platform, a public resource. That newsletter contained a campaign solicitation by Commissioner Bernard for her write-in candidacy, as well as incumbent Whitfield Calloway's soliciting votes. The department at the state level concluded that public resources were effectively used to distribute explicit campaign requests. Critically, Councilmember Whitfield Calloway's response to the department does not deny the use of these city resources. She merely points to a retraction after the fact, underscoring her control and supervisory responsibility over official communications. This is not a speculative or technical violation. It is confirmed and ongoing. It is not remedied by a belated apology or internal retraction. Most importantly, the Department of State acknowledges it can't resolve this before August 5th. If they cannot, and this court does not, the damage is irreparable and uncorrectable after the ballots are cast on August 5th. Your Honor, injunctive relief is fully justified on each of the four Michigan standards. The likelihood of success on the merits, because the department's findings mirror the plaintiff's allegations distributed by city resources for campaign purposes, admitted by actors involved. The statutory violation is plain. As to irreparable harm, the court and the department both recognize that post-election remedies are futile where the harm is to fair and lawful conduct of the election itself. No civil penalty or administrative correction can undo an election tainted by the improper use of public office for political gain.
Undo an already addressed issue that is
finished. Thank you. The balance of harms. The only burden on defendants is to follow the law and refrain from further violation. The burden on the plaintiff and the voting public is lost confidence in an unfair election should violations go unchecked. In the public interest, the state's own investigators have confirmed that this threat to election integrity and the public interest demands immediate court interventions where regulators cannot act in time. Your Honor, the court, let me say in closing, Your Honor, let me say in closing that the harm is ongoing and has been since early voting has begun. And it's continuing now. The actual election is August 5th. We have before us some people who violated the law. We have a board of ethics, which you can take their names off the complaint or not rule as to them or dismiss as to them individually. However, my case is predicated on the board of ethics addressing this because they have the immediate authority to either remove them from office or issue a reprimand that can be made known to the public prior to the August 5th election. And while it won't correct the harm done, it will mitigate it to some degree and provide the public of Detroit with at least a modicum of faith in our judicial system, providing and supporting the fact that we need an honest electoral process.
This circuit court is restricted in what it can do, and under the facts and the circumstances of this case, this court doesn't have authority at this time to
Your
act
Honor, this court
with.
does have
I'm
authority.
sorry. I'm sorry.
Would you like
I'm
case
going to have to
law?
mute you if you again are cutting me off in the middle of a sentence. I have to finish the sentence in that the facts and circumstances of this case don't allow this court to take action requested under a TRO or preliminary injunction. That is not within this court's authority. And so for that reason, the court has to deny the motion. Thank you.